Hear ye, hear ye, hear ye. The Honorable Presiding Judge Doyle and Associate Judges Tabor and Allers of the Iowa Court of Appeals. The Iowa Court of Appeals is now in session.
Thank you. Welcome to the Iowa Court of Appeals. I am Presiding Judge Richard Doyle, and on the panel with me this morning is Judge Mary Tabor and Judge Paul Allers. The matter before the court is Munoz versus Adventure Lands of America, case number 19-2097. Arguing for appellant Alisha Munoz is John Stoltze, and arguing for appellee Adventure Lands of America is Kelsey Knowles. All judges and counsel are present by video conference. The argument is being held as if parties are in the courtroom, and we are holding the argument by video conference under the authority granted by administrative orders of the Supreme Court. The argument is being streamed live for the public on the court's YouTube channel. Each side will have 10 minutes to argue, and the appellant will have 5 minutes for rebuttal. And with that, we will begin. Mr. Stoltze, you may start when you're ready.
Thank you, Your Honor. If it pleases the court, counsel. Your Honors, much like you, I came into this case as a third-party observer. I was not involved in the lower court proceedings and got brought in on appeal. I ended up taking on this matter because of the record that I saw that was rampant with material facts that were clearly in dispute. Of particular note of the material facts in dispute were the material facts that had to do with both disability harassment and gender harassment. Among those facts were included written statements and affidavits of 5 independent witnesses, along with Ms. Munoz herself, the appellant. And truthfully, it is surprising to me that this was summaried out.
Counselor, could I just clarify a bit of the record? Some of those affidavits of the coworkers didn't come in until the motion to reconsider, am I right? Or
some after, but the ones that were listed and are currently in front of the court in the joint appendix were all a part of the record, a part of the summary judgment record, Your Honor, ahead of the hearing.
Okay, thank you.
All the affidavits listed involve a whole bunch, a litany of harassing behavior by Ms. Munoz's supervisors, especially coworkers, supervisors, especially. Joint Appendix 279 through 280, where it was Alisha Munoz's affidavit. But if we were to look at just the independent witnesses, Joint Appendix 281 has the affidavit of Tyler White. Well, the statement by Tyler White, where after Ms. Munoz brought in a doctor's note, she was consistently told she was worthless. Joint Appendix 282 had the statement of Paige Berger, along with Joint Appendix 286, Your Honor.
Mr. Stoltze, looking at some of those statements, though, don't our rules of civil procedure require those to be affidavits and not just statements? These appear to be unsworn statements, some of them anyway. Are those things that the trial court could consider or that we can consider, given the fact that they're not affidavits or otherwise somehow sworn testimony?
Your Honor, I'd say that the affidavits that were at least signed have some semblance of procedure that they may be affidavits, but at the very least, Joint Appendix 308 and 310 are actual affidavits by Jamie Batten-Yarian. I came to knowledge after filing the brief that Ms. Batten-Yarian was also Ms. Yarian. So, and that in fact was an affidavit, and that listed in and of itself that a litany of statements by so many of her supervisors, Dave, Bill, and Gary, as it's listed in her affidavit. And in addition, she witnessed a situation regarding the doctor's note, and the doctor's note not being accepted in regards to the disability discrimination for failure to accommodate. But nonetheless, that in and of itself is an affidavit independent of Ms. Munoz's testimony and her own affidavits. While there are a litany of material facts in dispute, one of the things that I noticed when reviewing the order of the Supreme Court is that it had a striking similarity to the brief of summary judgment by the defendants in this matter. And there was one actual noticeable difference between the two of them, that the brief by the defendants actually included something that the order on summary judgment did not include, which included facts of disability discrimination, disability harassment that was included outside of the prescribed time that the lower court decided to limit it to. Nonetheless, the facts were rampant that both the independent affidavits and the deposition were rampant with facts that showed that Ms. Munoz had in fact suffered from harassment far outside the district court's limiting time frame.
Counsel, could I ask you about the adverse employment consequence and the difference of opinion on whether your client resigned or was terminated?
Yes, Your Honor. My theory on that would be the fact that as stated by Ms. Munoz's lower court counsel, she went into her supervisor to try and speak to his supervisor regarding the issues and have a conditional resignation in that fact. Before she could actually have a conversation with them, she was then thereby terminated. This was then continually corroborated by the emails sent by Mr. Bessart afterwards. One of the things that happens with this situation, is that Ms. Munoz had complaints that she was continually saying over and over and over again. And it reached a point where she wanted it to either end or she was going to stop working there. Which moves back into the harassment in and of itself. The harassment was never taken care of, Your Honor. Truthfully, I don't know how any person could deal with the fact that they could be called bitch multiple times throughout their employment and there not be harassment in it, especially when it gets said by male supervisors to female supervisors, such as you should work less hours because you become a bitch if you work too much, or in essence, the theory that Hispanics beat their bitches is what one of her supervisors told her when she showed up to work with some bruises on her face. She truthfully was being harassed for her gender, and the fact that it was left out of the actual decision was, in my opinion, an issue that the trial court needed to deal with. Of particular note, and I suppose this is might be why the district court limited it to limited harassment to not only disability but to the certain time frame, was the joint appendix page cited by defendant appellate, joint appendix 379. Immediately after the listings of that the harassment claim is based off disability, the very next question states,
which page of 379 are you on, since you submitted a condensed transcript? There's 4 pages we're talking about. Which page are we talking about?
Yes, Your Honor, page 203. It was 202 into 203 is is what the defense cited to. If you look at page 203, line 8, up above that, where it's questioned, up above that, where it says, provided examples, give details as to when each of the named harassers took or recommended one of the above actions. And then jumping down to line 14, Dave would make fun of me when I got my hair cut shorter every 4 weeks, ask if I wanted to be a man. Truthfully, the defendants were put on notice that this was a gender harassment case along with disability harassment. To try and pick and choose out of a deposition certain questions and answers when the deposition was laden with harassment based off of a gender context is to try and assess it as if you can't say multiple things multiple times and then one time say a different thing. I mean, it'd be the equivalent of the Salem witch trials. I'm not a witch, I'm not a witch, I'm not a witch. But then next thing you know, oh, I am a witch. Well, we're going to burn you at the stake. Nonetheless, the gender harassment was not considered, Your Honors, and it really should have been. The lower court counsel brought it up in their brief. They brought up a litany of other facts for disability harassment in their brief. And in hearing, gender harassment was brought up, and it would have then been assessed. When he brought it up in the motion to reconsider, it was, and you can actually see on 262 of the joint appendix, I believe, is order page 3, the transcript page 3 by the page 3 or 4 by the motion to reconsider, Your Honors. The court actually asks if the gender harassment stuff was in the record. Notice, I believe the court noticed at that point in time that there may have been an issue of gender harassment that was not ruled upon. Thereby, it should have been ruled upon. This also culminates in the disability harassment, Your Honors. However, due to the fact that my time has expired, I yield the floor currently.
Thank you, Mr. Stoltze. You'll have 5 minutes on rebuttal. Judge Tabor, do you have any follow-up questions?
Not at this time, thank you.
All right, Judge Allers.
I do not. Thank you, Judge Doyle.
Mr. Stoltze, you may begin your rebuttal.
Thank you, Your Honor. I'd like to focus back onto the petition, Your Honors. Ms. Knowles had indicated master of petition as being some sort of theory that the court should adhere to. However, the undisputed case law is obviously U.S. Bank v. Barber. That's where a notice pleading state, and also Lamantia, which was cited quite often in the appellant's reply brief, where the theory of the cause of action, as long as the elements are stated in the petition, is there. Whether it was labeled one thing or another, and excuse me, Your Honors, do you mind if we pause for a second? My light has turned off.
Oh, we can see it just fine.
And then it just turned back on. Okay, pardon me. Okay, Lamantia essentially says that as long as the causes of action and the elements are listed, then therefore, as long as the elements are listed, then therefore the defendant is put on notice.
Well, but when that's vague, so they don't know what the claim is it a harassment based on disability? Is it race? Is it gender? What is it? Aren't they entitled to then flesh out that information through, Ms. Knowles is saying they asked about this at the deposition, and she pinned it down and said it was just the disability discrimination.
She attempted to pin it down and portrayed it as pinning it down, Your Honor, but in fact, it was anything but pinned down. Joint Appendix 342, deposition pages 54, 55, talking about everything, talking about the harassment. Joint Appendix 344, 64 through 65, less hours because she was a bitch. When she works more hours. Joint Appendix 347, deposition pages 74 through 75. Bushek's comments about Latinos beating their bitches. Joint Appendix 347 through 76 through 70, depositions pages 76.
But what Ms. Knowles is saying is when she was specifically asked, saying, okay, you've alleged harassment, so just talking about the harassment count, how were you harassed? And she lists off all these things about disability discrimination, and then she says any other forms of harassment, and she says no. I understand that she's commented disgruntlement about these other comments, and I'm not sticking up for those comments, but I'm just saying when it comes to harassment, when she's specifically asked, do you have any other examples of ways that you felt harassed? Didn't she pin herself down by saying that? Because as I understand it, the pages that you're citing are in response to different topics, different questions. But when she was actually specifically asked about harassment, she clarified that these were it. These were the only things that she can think of that made her feel harassed.
Well, Your Honor, one of the things that I could say is how often when you basically screamed your lung when someone has screamed their lungs out about this, that, or the other thing, then they're asked, well, is there anything else that you feel harassed about? Then truthfully, it cannot be that it was only based off of one thing. And to use that such type of wordplay to try and remove a claim for gender harassment when clearly gender harassment was an issue, both listed in the petition, listed in affidavits, and listed countless times in the deposition. Clearly, it's a wordplay trying to limit the trial on the merits rather in an attempt to confuse and hammer down a layperson who may not understand all the theories about harassment. That
Would you agree that the petition was vague enough that there was some uncertainty as to what exactly the harassment claim was based on? Whether it was disability, gender, race, some other basis?
Your Honor, I don't think the petition was vague in that aspect. I think it was based off of all of those things. There was listing in the fact section in the amended petition. I don't have the joint appendix page quite often, but I believe it was paragraph 33 or 34 in the amended petition, where it listed off a number of harassing situations that had to do with a variety of topics. Now, Your Honor, if we have to narrow, I don't believe that there's any case law saying that it has to be one harassment claim or another. There's multiple. Obviously, harassment is a cumulative phenomenon, as stated in State v. Watkins, and therefore, why would there not be a harassment? Why could there not be a harassment based off multiple protected characteristics, Your Honor? And why would the defendant not be put on notice that is based off all those multiple characteristics when clearly gender situations were listed in the petition? I mean, it's clear that it was based off of multiple harassment types, and to attempt to limit it by 5 lines of a lay person's testimony and ignoring the entirety of the deposition seems to go contrary to, putting facts in the light most favorable to the plaintiff, and in fact also having a trial on the merits, which is the summary judgment standard, Your Honor. I mean, I understand where your thought process is on it, but I can't agree that a layperson is going to have the same understanding when they're being grilled for hours on end by an attorney who knows that if they just say this question just right, they may be able to hammer down the plaintiff into something that they just can't explain, despite every single instance otherwise in the deposition, which is in fact one of the issues that popped up in Gray Exwell Gray v. Baldy, which was cited to by the defendant in this case. The only issue is it wasn't trying to Ms. Munoz wasn't trying to avoid summary judgment during her deposition. Instead, she was stating in her deposition all the times that she's had problems. And the very next question after Ms. Knowles cited to testimony involves words said, named harassers, and Dave would make fun of me when I got my hair cut shorter, asking me if I wanted to be a man.
That answers my question, Mr. Stoltze.
All righty. I see your time's expired, Mr. Stoltze. Judge Tabor, do you have any further questions?
Just one quick clarification. So if we were to agree with the district court that we're limited to looking at a disability discrimination claim, is it your position that there's enough on the hostile work environment, enough comments targeted at that to get by the summary judgment motion as well?
Yes, Your Honor. And in fact, we listed a number of those facts in the brief. I mean, the truth is she was throughout her employment, she was listed as Alisha the Bruised. At one point in time, she actually even soiled herself and had to start wearing adult diapers because she wasn't relieved for bathroom breaks. When she did get bathroom breaks, she was harassed throughout her employment and being made fun of for those very same bathroom breaks. She was called worthless. She was called only good for bringing money to the bank. She couldn't do her job. Why was she even there? Because she had restrictions. I mean, clearly there's a record also rampant with disability harassment in this case as well.
Thank you.
And thank you, Your Honor.
Judge Allers?
I actually have two. I think they can be answered very briefly, so I'd ask you to do that, Mr. Stoltze. The first question is, there's an allegation that to the extent that there's any disagreement about, I call it the exit interview on September 3rd, that your client's kind of trying to weave in a constructive discharge claim. Would you agree that constructive discharge was not pled in the civil rights complaint and therefore cannot be pled here?
Your Honor, I believe that was an error by the district court, and in fact, a misconstruction of McElroy. Pulling to McElroy, Your Honor, at page 390 in McElroy, the courts listed that as long as the administrative complaint of the ICRC and of any administrative complaint is construed liberally to further remedial purpose of the civil rights complaint. So as long as anything is substantially related to the to the claim, then it's considered exhausted administratively. Therefore, and I'll finish the brief discussion. In her civil rights complaint, and I believe that's joint appendix, in her civil rights complaint in pages 2 through 5 of the summary of allegations, she lists out a number of issues that would be substantially related to constructive discharge. Thereby, it would have been exhausted administratively, Your Honor.
Right. And then my second question was, you've referenced in your brief this soiling herself because she wasn't allowed to go to the bathroom. Can you point where in the record there's any evidence of that?
Your Honor, I believe we cited to it in the portion of the brief that we cited to it. We cited to the exact fact in the portion of the brief where it got brought up. I don't actually have the joint appendix page.
Fair enough. Thank you.
Thank you.
Alrighty. Thank you, Mr. Stoltze. The case of Munoz versus Adventurelands of America is now submitted. The court will issue a written opinion in due course. Thank you, counsel, for your arguments. And the court is now in recess.
Thank you, Your Honors.
Thank you.